buttons on this one. So how do I get them? Hello. Good afternoon. This is Dr. Oluwasekun here again. Welcome to our live podcast. We want to apologize again. All this equipment, despite all the series of tests during the week, everything seems to be working perfectly. But now again, we are back. The audio is not working. So bear with us. We are going to continue. We have to improvise, make use of what we have. We are continuing today with the Detention series. Today is the part 2 of the Detention series. Last week we discussed the detention, what to do when somebody is arrested by ICE or CBP or any other agency of the United States government. So today we are continuing with the detention series. So now, assuming that you have been arrested by ICE or any other agency, what do you do? Of course, last week we talked about you contacting your immigration attorney, having your alien number handy because no lawyer can do anything without the alien number. So next, what do you do next? The next thing is once you contact your immigration attorney, the attorney will ensure that you are processed, and after being processed, then the attorney will apply for bond for you, depending on the reason why you are picked up in the first place. There is every likelihood that you will be eligible for bond. There are only very limited situations where somebody is not eligible for bond. For example, if you are a permanent resident who travel outside the United States and you are returning to the US, and of course you have a criminal conviction which was brought up at the point of entry when you are coming back, if you are detained as an arriving alien, there is no bond. In such a situation, you will not be granted bond. But again, you still have to contact your immigration attorney, because even though you may not be eligible for bond, your attorney still have to immediately present whatever relief you have so that your case can be expedited before an immigration judge. But the point I'm making here is that anyone entering the United States as an arriving alien is not eligible for bond. Secondly, if you have aggravated felony, you may not be eligible for bond, especially if there is no relief. It doesn't matter whether you are already a permanent resident or you don't even have legal status. If you have aggravated felony, you may not be eligible for bond. So those are statutory requirements. So there is really nothing anybody can do about it. So you will be detained while the case is being processed. But again, it is always good to quickly contact an immigration attorney so that at least they can ensure that your case is expedited. And of course, it is also in the interest of the government to have your case expedited, because the government will be spending money keeping you in detention. They have to keep you, give you food. If you are sick, they have to provide medical. So it's also at the government expense. So usually detained cases are given priority at the immigration court. So now, if there is, can you please reduce that? It's distracting me. I got distracted now. What was I saying? Now, usually once you are detained, especially if there is no bond, just immediately contact the immigration attorney so that they can present whatever relief you have to the immigration court, and the case can be set for hearing as quickly as possible. Usually, there have been situations where cases are set within 2 weeks, especially if it's a case of non-bond, where the client is not eligible for bond. So the case may be expedited and hearing can be set within 2 weeks, or at most within 4 weeks. But again, hearings are given priority in a detained case, in every detained case. It doesn't matter whether you are a permanent resident or whether you don't have papers. Once you are detained, hearings are given priority. Now, if you are eligible for bond, you or your lawyer apply for bond from ICE. ICE is the detention agent, Immigration and Custom Enforcement. Most of the time, they are the one that detain. That does not mean that other agencies do not detain, but it is the responsibility of ICE to detain. ICE is like the enforcement arm of immigration. They are like the immigration police. So they detain you and you can apply for bond with ICE. However, in some cases, ICE may deny you bond or set a bond that is, I don't want to use the word unreasonable, but that is excessive. For example, I've seen situations where ICE set a bond of $25,000. I mean, that is, in my opinion, very excessive for immigration cases, especially considering the fact that immigration bond has to be paid in full. It's not that you pay 10% or you pay certain percentage or you'll be making monthly payment or installment. No, for immigration bond, you have to get cashier's check in the full amount. Therefore, setting a bond of 25,000 for somebody who probably doesn't even have papers to be able to work or do anything is purely excessive, in my opinion. And of course, in some cases too, ICE may even deny you bond outright. They may deny your request for bond outright. So what do you do in such a situation? Again, if you have an immigration attorney, they can apply they can apply to the court, to the immigration court, for immigration bond redetermination. If no bond has been set, you can apply to the immigration court for bond determination. But where bond has been set and denied, you can apply to the immigration court for bond redetermination. So it is always good to enlist the services of an attorney with experience, because some of these things are a little technical. It is important to point out whatever relief that you may be seeking. It is important to show that you will not be a flight risk. It is important to show that you have family ties. There are a few things that have to be showcased in the bond application in order to ensure that the judge will grant it. And if you believe that the bond is, if you believe that you are eligible for bond, and if the immigration judge deny your bond request or set an excessive amount, you can also appeal. There is room for appeal. You can appeal the bond determination to the Board of Immigration Appeal, because sometimes too, I've seen immigration judges even set excessive bond amount. For example, I've seen a couple, a husband and wife, detained, and the judge set bond of $20,000 each for each of them. So between the husband and wife, it means they have to cough out $40,000. So indirectly, that is it is an indirect way of denying the bond application, because how are they going to get 40,000? The same couple coming, generating income from the same source. Where are they going to get 40,000 cash? Like I said, for immigration bond, we are not talking about percentage. It has to be the full amount. They will not even accept checks. They will not even accept any other credit card. They will only accept cashier's check. So what are we talking about here? That's an indirect way of denying a bond if such an excessive amount is set. But again, because the immigration judge is not the final authority, if an excessive bond is set or if a bond determination is denied, then you can appeal to the Board of Immigration Appeals. I can see that questions have started coming in. So, oh, I think something is wrong here. I don't know. Maybe you help me how I can see the questions. So we are discussing bond today. We are in part 2 of the bond series. So if you have questions, send in your questions. You can text your questions either on regular phone or on WhatsApp to 817-983-4499. 817-983-4499. You can also send it to 817-891-6655. 817-891-6655. You can also send it to 817-883-4495. You can send your questions to 817-983 4499 or 817-891-6655 or 817-883-4495. Okay, the first question here, is bond refundable? Oh yes, that is a very good question because we part of the same question.
No, there are many questions before that.
Or before that?
Yes.
Okay, since I already started answering that, the question is fund refundable? The answer is yes. Because we are talking about you putting up the entire amount. Not only is the bond refundable, it is actually refundable with interest. It is refundable with interest. So once you pay the cashier's check in the full amount and you continue with your removal proceedings, when the case is finally over, it doesn't matter how the case ends. When the case is finally over, you are entitled to the refund of your bond. If you succeed in getting legal status, let's say you apply for asylum, for example, and at the end of the day, you are granted asylum. After the grant of the asylum, you can go back to ICE office to request the refund of your money. If you use a sponsor or a guarantor, whoever pays the bond or serve as your guarantor is the person that can go back to request for the refund. So they will refund the whole amount plus interest. The whole amount plus interest. Even if, worst case scenario, even if you are deported, for as long as the person who paid the bond, the guarantor, is here in the United States, they can go back to ICE office to request a refund of the bond amount plus the interest. However, if you did not use a guarantor, if you posted the bond yourself and eventually you are deported, all you need to do is to sign an authorization for someone who can act on your behalf and request a refund of the money, of the bond money. Your money will be refunded in full plus interest. Okay. The next question, can I request for bond during a master hearing? Well, you cannot because when we are talking about bond is a separate application. Master hearing is a different hearing. I've seen a lot of people make this mistake. In fact, I've seen lawyers who lack understanding of the way immigration court works. When your case is set for master hearing, you go for master hearing. During master hearing, you cannot discuss bond because bond is a separate proceedings. So when you file an application for bond, your application will be set for a hearing. So that will be a bond hearing. So if you have a lawyer who appeared for you in a master hearing and then you are expecting that immigration court will deal with that lawyer during your bond hearing, no, the court may not. The lawyer will have to enter appearance separately for the bond hearing. So bond hearing, master hearing, they are two separate hearings. So if your case is set for bond determination, that is what the court will consider that day. If your case is set for master hearing, that is what the court will consider that day. It is only where the court gave you the same date for both your bond application and the master hearing that can happen. The court can give you the same date for your bond application and your master hearing. So like I said, in this case, the lawyer will still have to enter appearance twice. The lawyer will have to enter appearance for the bond application, and they will have to enter appearance for the master hearing, because for the master hearing and for the bond, even the court will open separate files. The files are not going to be the same. So if there are supporting documents that is provided in support of your bond application, don't assume that the court is going to see those documents in your master hearing. No, they will have to be refiled separately in support of your master hearing. So document you file in support of your master hearing cannot be transferred to your bond application because they are two separate files. So you need to understand that. But yes, it is possible that both applications can be had the same day, but they will have to be two separate proceedings and two separate files. The next question: what happens if I am found ineligible for any relief? Well, if you are found ineligible for any relief, then you can take voluntary departure. Otherwise, the judge will order you removed. If you cannot present any relief, it is unlikely that you will be granted a bond if there is no potential relief. Because what is the whole purpose of removal proceedings? For you to tell the court why you should not be removed. So if you are unable to tell the court why you should not be removed, the court is going to go ahead and order you removed. So if you want to prevent that, you can on your own, you can seek voluntary departure and leave on your own. But let me say this, from experience, if you are detained, even if you seek voluntary departure, they are probably not going to release you. They will tell you to bring your bag or get your family members to bring your bag to ICE. And then if you want voluntary departure, you don't want the government expenses, you buy your own ticket and you bring your bag. ICE agents are the one that will still take you to the airport from detention, and then you leave. But if it is a case of non-detained, if you are not detained, if you request voluntary departure, they can either grant it, the court can grant it for up to a maximum of 120 days, which is 4 months. Or in some cases, the court may ask you to post a bond to ensure that you will leave. That means you will put down some money with ICE, and then when you depart, you will show evidence that you have actually departed, and then that money will be refunded. So that is the way that works. The next question: can I present evidence of witness in my defense? This question is not clear. Witness in what sense? Are you talking about witness in support of the bond application? If you want to present witness testimony in support of your bond application, yes, that is possible, if that is what this question is talking about. Because when you file a bond application, there will be a hearing. So the hearing could be in form of documentary evidence, it will be in form of physical testimony, it could be your own testimony, and you can also have witnesses who can testify on your behalf. Yes, you can present witnesses because it is a formal hearing, and that hearing could be written and it could be verbal through physical testimony. The next question: how soon will a decision be made following the hearing? If we are talking of bond hearing, usually decisions are made the same day. Bond hearing is not something that is delayed. After the hearing, the immigration judge will tell you whether or not they are going to grant your bond request. So there is no provision for delay when it is a detained case. Usually, after hearing, right there and then, the judge will tell you whether or not your the decision right away. There is no delay. If the judge is going to grant your bond application, is going to tell you at the end of the hearing. And if there are conditions, the conditions will be announced at the end of the hearing. If there are no conditions, you will also know at the end of the hearing, because it is also possible to grant a bond in exercise of discretion. It is possible to grant a bond in self-recognition. One could be granted a bond without paying any amount. It is possible. Even ICE can grant a bond without payment of any fee. ICE can grant a bond in self-recognition as well, if they choose to do that. The next question: can I contact my family while detained? Oh yes. Once you are detained, you can have access to telephone. You can tell your detention officer that you want to make a call, and you can also get your family to do what is called collect call, which means they will put money in your collect call account, and you can call anyone that you want. And in some cases too, you can register the collect call and request the person you are calling to pay for it. The way that works is that when the person you are calling, when his or her phone rings, he will announce that this is a collect call and you will be required to pay for this call. Do you want to proceed? Do you want to accept to pay for the call? So if the person accepts it, then that person will be charged for the cost of that call. But if you have money in your collect call account, then you can pay for it as well. But it is always advisable, if you want to reach your family member, it is always advisable to put money in your own collect call account, because a lot of people, they set up their phone in such a way that it will not accept collect call. Even in our office, we do not accept collect call if we are the one to pay for it. So it's better to put money in your own account so that whoever you are calling will be able to accept that call. The next question: can my attorney request a bond from ICE? Oh yes. Oh yes, your attorney can request a bond from ICE. That is part of what attorneys do. Once you retain an attorney, you can request a bond from ICE. The next question. Hello, Dr. Shekun and team. Thanks for all you do. Oh, that's not a question. It's just a compliment. Okay, thank you. The next question: is the bond refundable? Okay, I already answered that. Yes, it's refundable with interest. The next question: if I have a lawyer that has G28 on file, can the immigration officer still talk to me without my attorney present? Yes, if you waive your right. Now, this is a very good question, because a lot of people, out of ignorance, they do things that get them into trouble. if you are detained and you have a lawyer who have G28 on file, that G28 puts eyes on notice that you have a lawyer. However, if your detention officer or any ICE agent or USCIS agent, if they want to talk to you, you as the client, you have a responsibility to tell them that you have a lawyer. An officer may come to you without actually reviewing your file, without realizing that you have a lawyer, or even if they realize that you have a lawyer, because you also have a right to either waive your right to an attorney or not, they can still proceed. So it is your responsibility to tell them that, look, I have a lawyer and I want my lawyer to be involved in this conversation. Once you tell them that, they cannot proceed, but they may ask you if you want to waive your right to a lawyer. That is within your right, so it's your choice, but it is always advisable not to waive your right, because there are so many technicalities involved in a lot of these things. You may end up signing your own deportation without realizing it, because one thing people don't know is that there is a machinery for expedited removal, and some of these documents may include provision that, okay, I don't want to go through immigration court, I don't want to go through the immigration process, I consent to being removed expeditedly. So those documents they present to you to sign may have such a provision, and if you sign it, for as long as they didn't force you to sign, for as long as you didn't sign under duress, it's going to be difficult to turn around and say you didn't know, because that is why you have a lawyer. So if you have a lawyer and you choose to deal with them without your lawyer, and you end up doing something that implicate or that have negative effect on your relief, then you have yourself to blame. I mean, if you have taken the pain to hire a lawyer, why will you now be in a rush to not have your lawyer present when they want to talk to you? So that is within your right to either waive it or keep or maintain your lawyer. So it is advisable, if they want to talk to you, always tell them, and also have your lawyer's information handy. Some officers, they will not want to go through the rigor of going through your file to see who is your lawyer and all of that. Oh, I have a lawyer, my lawyer's name is Dr. Oluwasekun, here is his phone number. Always have that handy. Once you do that, they cannot proceed without the lawyer. The next question: after the bond is paid, how long will it take ICE to release the detainee? Well, payment of bond is one thing, and release of detainee is another thing, because most of the time they are not done at the same office. For example, immigration have different detention centers. Many of these detention centers, 99% of them do not process bond. So bond is processed in ICE office. So it is important to notify the detention center after the bond has been paid, to let them know that the bond has been paid. Usually ICE is supposed to do that, but I will not wait for ICE to do it, because until the detention center receive information that you have been granted bond and that your bond has been paid, they are not going to release you. Sometimes some of these ICE officers, as soon as they collect your money, they notify the detention centers, but sometimes they may be overwhelmed, they may not do it right away, and in the process they may forget. So if you don't do it, your family member or you yourself, you'll just be languishing in jail even after paying the bond. But once you notify the detention center, they are not going to release you, but they have an obligation to verify So once you notify them, they will contact ICE. Is it true? Can you confirm that this person has paid the bond? And once it is verified, then they release you immediately. And I think, if I recollect correctly, I think most ICE offices, they have cutoff. I think a bond that is paid for before, I think they are cut off, if I recollect correctly, is around 11 a.m. If a bond is paid before 11 a.m., the likelihood that you will be released the same day is very high. But if your bond is paid after 11 a.m., you may not be released until the following day, even if you notify them. So these are important informations to note. The next question: how do we know when someone has to appear in court? Well, if you are detained, because there's a separate process for people who are detained versus people who are non-detained. If you are detained, you will know. Even if they didn't give you advance notice, detained cases, majority of detained cases are had through electronic means. So they will tell you, oh, tomorrow morning you have a hearing at 8 a.m. So they will gather all of you that have that hearing in detention. They will take you to a room in the detention center where there is a big what do you call this thing?
Screen?
Yeah, it's not.
Camera, like a TV, or is it like a computer?
Sometimes it is TV. Sometimes, Marissa, what do you call this? If you have a computer and you have something.
Like a webcam?
No, there's a word I just can't remember.
You have something like
Where you can see the
webcam?
you can see what they are projecting.
Projector?
No. You know, in those days they used to sell computers separately, and they sell the, what do you call the one that you see yourself?
Webcam.
Not webcam. Not. Anyway,
Uh-huh.
you see yourself. They use this. There's a word that I'm trying to remember. I can't remember the word. Monitor. That's what I was pointing to.
Oh, the
Monitor.
monitor. Okay.
Yes.
Oh, I'm sorry.
So most of the time, when someone is detained, they use electronic monitor. That is where you approach the judge. Majority of the time, the judge is not going to come to the detention center, and you are not going to be transported to the immigration court. So majority of the time, it is through the screen. You see the hearing is conducted through the screen. So they will bring you into a room where you see that monitor, the big screen monitor, where you will talk to the judge, and the judge will also talk to you. If you have a lawyer, the lawyer will be present in the court talking to the judge while you are in the detention center talking to the judge through the monitor. The next question: who set the bond amount? Well, if it is ICE bond, it is the officer or the officer supervisor that set the amount. But if it is the immigration bond, it is the immigration judge who set the bond amount. Again, when you apply for bond, part of the evidence that you present is your ability to pay. You let the judge know that, look, I don't have the financial capacity to pay a lot of money. I'm not a flight risk. I have this relief that I'm going to apply for. There is no way I will not come to court because I have this relief. And if this relief is granted, I will have my legal status. So I don't have any incentive not to appear. But I cannot afford a lot of money now. So it is the judge that will determine the amount. But if you don't make a good presentation, the judge does not know your financial capacity, they can set some high bond amount. But it doesn't matter your financial capacity. If a crime is involved, the bond amount will naturally be very high, even if you are eligible for bond. The next question: what can be used as collateral? No, immigration bond, they don't accept collateral. You have to pay the cash. They don't accept collateral. It doesn't matter what you have. Even if you have a house, they are not interested. For you to get immigration bond, you must present the physical cash in form of cashier's check. That is the only thing immigration accepts, nothing else. If you don't have money and you have access, maybe you go to loan places or something to apply for loan, to use your collateral to apply for loan. But as far as the immigration is concerned, you pay the physical amount in the form of cashier's check. The next question: my spouse is a legal permanent resident who has a citizenship application pending. He was arrested and now is detained. What happens to the citizenship application? Well, this question is not complete because I don't know why this person is detained. Was this person detained because of a crime, or okay? If the person is arrested for a crime, first and foremost, the citizenship application is going to be placed in abeyance. That means they are going to put a hold on it. They are not going to adjudicate it, because number one, they cannot approve your citizenship application when you have a criminal case pending. It is against the law. They cannot. And number two, an accused person is presumed innocent until proven guilty. They can also not deny it by assuming that you are going to be found guilty. Because you are presumed innocent, they cannot use that arrest to deny your application. So the only thing they can do is to put the application on hold until that case is over. Once the criminal case is over, then if you are discharged and acquitted, then they will go ahead and adjudicate your citizenship application. However, if you are convicted, they will probably deny it, because one of the requirements for citizenship is the evidence of good moral character. And whenever somebody have criminal offense, it may show that you lack good moral character. However, this is not a one-cap-fit-all. There are some crimes that may not affect your citizenship application. So it depends on the fact of the case. And this is one of the reasons why for immigration purpose, they don't use only conviction document. For immigration purpose, whenever a crime is involved, they use three things. One, they use what is called police incident report. This is not police report. Police incident report. It is different from police report. So they use police incident report. Two, they use whatever charges you are charged with. And three, they use the conviction or the decision. Were you convicted or were you acquitted? So whatever, even if the charges were later dropped, because immigration is going to look at the police incident report, they are going to see exactly what happened, why you are even arrested in the first place, why you are charged to court, whether your conviction was based on the skillful performance of your attorney. All that is going to be taken into consideration. So even if you are convicted of a lesser charge, your citizenship application can still be denied if the basis for the arrest is what immigration considered evidence of lack of good moral character. Let me give you an example. Maybe somebody is arrested for domestic violence. Domestic violence is one major offense in the United States that maybe 50% of the time the victims do not cooperate with the law enforcement. This is because even though this person has been is a victim, they don't want their loved one to end up in jail. Sometimes other family members will put pressure. Oh, we know that what your wife did is not good, or what your husband did is not good, but sending him to jail, that means you are going to be a single parent. The responsibility of taking care of the children will be only yours. You don't want your spouse to go to jail. Sometimes they put pressure. So at the end of the day, the victim end up not cooperating with law enforcement. So if that is the situation that led to your non-conviction or a reduction in the charge, immigration is still going to take the domestic violence into consideration in denying your application for citizenship, because as far as immigration is concerned, the law allow them to make a determination that someone lack good moral character. And when we are talking of lack of good moral character, it could be whatever you are arrested for. It could be because you owe IRS tax. It could be because immigration determined that you drink too much. It could be for a variety of reasons. So irrespective of the outcome of the criminal case, your citizenship may still be denied if immigration believe that you lack good moral character. The next question: if I'm ordered removed, how long does it take for them to deport me? Can I be let out while waiting for them to remove me? Well, every case is different. I've always said it on this podcast. Immigration is not a one cap fits all. Every single case is different. If you are ordered removed, immigration does not have time limit. Somebody may be ordered removed and that person may be deported within a week. Somebody may be ordered removed and that person may still be in this country for 5 years, even after the order of deportation. I've seen this thing happen. There are so many factors that affect removal or deportation. Number one, and the most important one, is that this person they want to deport, do they have a certain country that they are sure that this person is from this country? You know, there are some people that are stateless, especially people who come in through the border. They did not present any passport of any country. So immigration will have to determine which country they are going to deport them to, and that country will have to be willing to accept them. I've seen somebody, I can't remember the precise year, but I think it's probably almost 20 years now, who has been ordered deported. But this person is still in the US because this person has a name that is similar to one particular country in Africa. This person came into the US with a passport from another country. Now, when this person was ordered removed, the country that issued the passport that this person came with, they declined that this person is not their citizen, that this person cannot be deported to that country. The other country whose who has a name similar to the name that this person answers, of course, they said that this person will have to apply for passport in order for them to issue travel document, because this person have to provide the local government or the state where he or she is from and all of that. So at the end of the day, immigration was not able to obtain a travel document up to today. This person is still in the US, even with a removal order that is hanging on him. In fact, subsequently, no, the person is not detained. Subsequently, this person had another relief, became eligible for another relief, and this person filed a motion to reopen with the immigration court, and the immigration court denied it. I represented this person in filing the motion to reopen. The immigration court denied it. We filed an appeal to the Board of Immigration Appeal. The BIA also denied it. And their reason for denying it is that for them to reopen anything, this person really have to tell them, come up, which country is he from? And he needs to apply for passport from that country. But the fear is that if this person decide to apply for that passport, then he will give them the instrument to use to deport him. So he didn't want to do that, and the court also didn't want to reopen his case. This person is still in the US despite being ordered removed for almost 20 years now. The next question: what are the conditions for voluntary departure? Well, voluntary departure is a discretionary application. However, there are some basic requirements. Number one, and the most important thing, most judges will ask the government whether they are opposed to voluntary departure or not. So if the government, that is ICE through their lawyers, if they are opposed to voluntary departure, then the judge will now determine whether to grant it or not. But what the judge will look at, number one, does this person have any criminal record? If there is a criminal record, they may conclude that this person is not eligible for voluntary departure. But most of the time, if there is no criminal record, the court probably will grant voluntary departure. The only thing is that if the government is opposed to it, the court may impose a bond. They may ask the respondent to post a bond to show that he or she will depart at that time. The court may also reduce the time, even though the court can grant a maximum of 120 days, which is 4 months. It does not mean that the court is going to grant it. The court may give this person 30 days, especially if the application for voluntary departure is opposed by the government. The court may grant it only for 30 days. In fact, I've seen 2 weeks before. I've seen voluntary departure granted for 2 weeks, and I've also seen substantial amount of money imposed as bond just to ensure that this person leave. Then the third thing that the court most of the time look at when you are asking for voluntary departure, the court want to see evidence that you can actually afford to buy your own ticket. So if you tell the court you want to depart, they want to see evidence. If you need to buy a flight ticket that is going to cost 2,000, show us that you can even afford that. Because if you cannot afford it, how, if they allow you, if they grant the voluntary departure, how are you going to leave if you cannot even afford your own ticket? So most of the time, the court may even impose a condition that requires the respondent to buy the ticket, to purchase the ticket and submit it to ICE before they even release the person from detention. So a lot of conditions can be imposed, but most importantly, they look at criminal record, they look at your ability to afford the cost of departure, they look at whether the government is opposed to it or not, and they look at the general circumstances of each case. They consider the issue that led you into, that brought you into removal proceedings in the first place. They consider all of that. The next question: can I come back to the US after voluntary departure? Oh yes, voluntary departure, one of the benefits of voluntary departure is that it does not count as deportation, and that is why they don't just grant it for everybody. Voluntary departure usually does not count for deportation. So the effect of voluntary departure is like somebody who came to the US, overstay, or somebody who came illegally and then on his or her own departed. That is different from somebody who is deported. Anyone who is deported from the US, for you to come back to the US, you have to apply for a waiver. There is something called I-212, application for advance permission to reapply for admission after deportation. But somebody who is granted a voluntary departure does not need to do that. It is as if you left on your own voluntarily. So it does not count as deportation. That is one of the benefits, one of the major benefits. But let me tell you this. I don't want anybody to misunderstand me. Voluntary departure has its own disadvantages, a lot of the disadvantages. Number one, and the most cruel, the most dangerous disadvantage of voluntary departure is if you apply to an immigration court for voluntary departure and that voluntary departure is granted, if you fail to depart, you cannot apply for adjustment in the US. So it has its own disadvantage. So if you are not planning to leave, don't apply for voluntary departure. It has its advantages, but it also has its disadvantages. If you are not planning to leave, my listeners, please do not apply for voluntary departure. It is extremely difficult to fix. If you go to, that is one of the reasons why before a voluntary departure is granted, the judge will explain to you in great detail. Even if you don't speak English, they will get an interpreter to translate to you the implication of what you are saying. Because once your voluntary departure is granted, if you don't leave, you cannot come back to apply for a benefit. They will deny it. So think twice about it before you go that route. The next question. I think the last one I answer is the one, can I come back to the US after voluntary?
Yes.
Yes, to answer that question directly, yes, you can come back after voluntary departure. That is one of the benefits. If you have a relief, let's say you file something, maybe you are not eligible for adjustment of status, but you have an I-130 petition that was approved on your behalf, you can still return to the US by going to apply for immigrant visa at the embassy. Yes, you can come back because it does not have the effect of deportation. That's the advantage. But it also have its own disadvantage, which is that you may not be able to apply for adjustment if you refuse to leave. Does that affect what we are doing?
No, just the sound. You can you unplug? Okay.
Hello?
you-
Can
no.
you,
Can you hear me? Can you speak?
hello? Can you hear me? Yeah, I think they
Yes.
can hear me.
Yeah.
Okay, the next question. If I'm applying for asylum while in detention, does the government have to provide me with an attorney? No. For immigration benefit, immigration is different from criminal defense. For immigration, foreigners do not have right to attorney. It is your own responsibility to provide a defense for yourself. It is your own responsibility to get an attorney for yourself. It is not the responsibility of the government. That is only applicable in a criminal trial. In a criminal trial, the government has a duty to provide you with an attorney. But in an immigration case, the government does not have any such duty. It doesn't matter whether you are detained or not. It is not the duty of the government to provide you an attorney. The next question, how can I request voluntary departure? Usually you request voluntary departure from the court during either, there are two types of voluntary departure. In fact, there are three types. You can request for voluntary departure from ICE directly. If ICE decide to grant you voluntary departure, they will just need to come back to the court and announce it to the judge. So you will tell the judge that both you and the government, you have reached an agreement for you to take voluntary departure, and the government is willing to give you voluntary departure. So once there is an agreement, the judge will not have a choice. The judge will grant you voluntary departure, except in an extremely uncommon case where the judge may disagree with the government. I've seen that happen, but maybe less than 1% of cases where the judge may disagree that, you know what, this person is not eligible for voluntary departure and I'm going to deny it, despite your agreement. That may happen. But ICE may grant you voluntary departure. That is one way. The second way of applying for voluntary departure is to apply during masters. To apply for voluntary departure during master hearing. This is called pre-conclusion voluntary departure. You have not even, the case has not been heard, you have not gone into any trial, you have not wasted the time of the court, you are just telling the court the first time you come to court or any of the master hearing that, look, I don't want to contest this case, I am prepared to leave, just give me 30 days, or just give me 60 days, or give me 90 days, or give me 120 days and I will leave. So that is called pre-conclusion voluntary departure. Most of the time, except there are criminal issues, most of the time, the government does not oppose a voluntary departure when it is pre-conclusion, because they also see it as, okay, this person is not wasting our time, we are ready to allow you to leave. The third way to apply for voluntary departure, maybe you have tried everything possible. Maybe you apply for asylum, it has been denied. Maybe you apply for cancellation, you have presented all your relief and everything has been denied. But before the court order you removed, you now tell the court that, look, you either grant this relief, or in the alternative, if you believe that you don't want to grant me the relief, grant me voluntary departure in the alternative. That is called post-conclusion voluntary departure. Many times, the government will oppose it, but not all the time. But because they believe that your relief is probably not meritorious, it's probably not going to be granted. But again, they don't know yet because the judge has not ruled by the time you present this. So they may still agree, but they may also disagree. So those are the three ways to get voluntary departure. The next question, what are the consequences of violating voluntary departure? I think I already explained that. If you get a voluntary departure and you don't leave, it prevents you from being able to adjust in the United States, because they will not approve anything you file subsequently. Let me also say this. If you apply for voluntary departure and you are granted voluntary departure, if you file a motion to reopen or reconsider after the voluntary departure, the voluntary departure will automatically be converted to a removal order. In that case, there is no voluntary departure. Your voluntary departure will be converted to a removal order. So from that moment you file your motion to reopen, you are no longer considered somebody with a voluntary departure. So that voluntary departure will be converted to a removal order. The next question, What happens if I come back to the US after leaving on voluntary departure? Well, if you re-enter legally, you'll be able to adjust or do whatever you need to do. But if you re-enter illegally after being granted voluntary departure, it depends on how long you are in the US unlawfully prior to the grant of voluntary departure. It may trigger a permanent bar. Permanent bar is when somebody has been in the US unlawfully, or somebody entered the United States unlawfully, and you are here for at least 1 year, and then you leave the US and you re-enter the US the second time illegally. That is a permanent bar. Even if you marry President Biden's daughter, you cannot get green card in the US. It's a permanent bar, except you have some other basis to get green card. The next question: if you apply for asylum at the border, do they always detain you? Not in all cases. Not in all cases. The procedure for asylum at the border is different from the procedure for asylum inside the US. When you are at the border and you declare your intention to apply for asylum, most of the CBP officers at the border, they are not asylum officers. So they will not even take any application for asylum from you, because that is not their job. They will detain you, they will interview you, and then they will bring an asylum officer who will come and talk to you and conduct what is called as credible fear interview. Credible fear means that, okay, this person has the likelihood of being harmed if we send this person back to his or her home country. So if they make such a credible fear, from that moment, they have two options. They can release you on bond. They can release you on parole. They may also release you on self-recognizance, especially if you have a family member who is willing to guarantee that they will take you in. So if they do any of these things, that is still not an application for asylum. So from that moment, you have 1 year from the date of your entry, you have 1 year to submit an asylum application either to the court or to the immigration court. Usually you have to submit it to the immigration court, but if no notice to appear has been filed on your behalf, you can submit it to USCIS through what we call affirmative asylum. On the other hand, if they conduct credible fear interview for you and determine that your case is not credible, they can continue to detain you and ask you to sign voluntary return. If you do, they will send you packing. But if you tell them that despite their own assessment, you believe that you are eligible for asylum and you want the immigration court to review your asylum, they have no choice. They will have to present you to the immigration court, and you will have to file an application for asylum with the immigration court, and the immigration judge will now determine whether you are eligible for asylum or not. Okay, the next question: can you put a bond on a credit card? No, I'm sure this person didn't join early. The only way you can pay for bond is cash, through cashier's check. They don't accept a check, they don't accept a credit card, they don't accept cash, they don't accept collateral, they don't do anything. This is different from criminal bond. The only thing that ICE accept for the purpose of bond is your physical cash in form of cashier's check. That's it, nothing else. The last question: can you be deported without being put into removal proceedings? Oh yes, you can be deported without being put into removal proceedings, especially if you don't know your right, especially if you don't have an attorney. And even if you have an attorney, you still don't know, because like I said, the removal proceedings is a little complicated. Sometimes many of these officers, especially if you are applying for asylum at the border and they tell you that, oh, you do not have credible fear, they don't believe you, then they may give you a lot of documentations to sign. Many of these documentation will offer you that, look, you consent to being deported expeditedly. And if you don't understand, these things are complex. Even they are difficult for lawyers to read, not to talk of somebody who is not familiar with legal jargons. You may even be familiar with legal jargons and not be familiar with immigration language. That is why it is important for you to have an immigration attorney, because you may end up signing your own deportation without knowing it. I believe that's the last question for today.
Yes.
So, in the absence of any additional question, we are going to end this today. Remember to invite your friends, family, colleagues at work. We do this every Wednesday. Remember to join us 12 p.m. Central Standard Time. That is 12 p.m. Dallas time. That is currently 1 p.m. Eastern Time, 10 a.m. Pacific Time, and 6 p.m. Nigerian Time. Remember to join us next week. This is Dr. Oluwasegun. Also remember to follow us on social media. We do have reels where we provide daily information that is useful. So it is important that you share this information with others so that you are not selfish. We are doing this free of charge without any strings attached. So the only thing you can do to show appreciation is just to let others benefit from this wealth of free information. Thank you, and see you again next week.